Tom, do you think that Elon will start opening decision-making to the community through polls?
Well, he said he would. I don't have any reason to say to suggest he wouldn't. I guess my general concern is, my impression is his prior companies were run along traditional business lines. And he's come into what is essentially a quasi-government or political operation, where he's not controlling the direction of his company the way he might have in the other companies he's running. So he's under significant pressure. The fact that he's even asking this question shows he's under significant pressure. And, the political nature of what he's doing is completely alien to most people's experience, and certainly his. And he's being targeted, obviously, in terms of security, his personal security, in ways that we can't fathom. You've had the media happily participate in trying to dox him, as we've been talking about. And, then he does something like this over the last day, and he gets this negative reaction, and he must be extraordinarily frustrated. And in the meantime, the company isn't doing as well as it could. And anyone commenting on this or kind of participating in trying to influence the direction of Twitter, most of them, including, I would say, most of us, have little interest in whether Twitter is profitable or not. So I don't envy his position. I think it would be difficult to overstate what a lonely position he's in right now in terms of the decision making. He's not getting the rewards, obviously, from the media. He mentions something negative about Fauci, and he's attacked by the White House and members of Congress. He's being threatened by the European Union. His other companies are being targeted. And, one potential way out is maybe just take a step back from running Twitter day to day. And I would suggest to him, because of the political nature of what he's been doing, he's already assigned a target to his back that's never going to be removed. So, the political side, and I know it's easy for me to say, but the left is never going to stop. If he were to pull back right now, it would be a major victory for the totalitarian left that opposes free speech, and their despicable tactics that they've used to try to destroy him. And, and there's no way they're ever going to stop, because he's already outed himself as an opponent of their totalitarian push to end free speech, as any normal person understands it to be, to end free speech completely on these big tech platforms. The Federal Trade Commission, according to the New York Times, under Biden, just sent in recent months Twitter 2 letters demanding to know, harassing Twitter with demanding if they're complying with this consent decree that was signed on to Twitter shortly before Musk came on, related to privacy data management. It's just harassment by the bureaucracy. So you can bet he's probably had to disclose that, or probably did disclose it to some of his major financiers. And who knows what else is going on behind the scenes. Remember, this is not the only area under which he's under, it's not the only company that he has. And there are other, Tesla's under investigation, and the EU is threatening him every other day over every decision he makes.
Now, Judicial Watch is also the national leader in trying to figure out the truth behind the scandals around COVID-19, whether it be the origin of the underlying virus, the vaccine controversies, and the government's handling of issues related to the vaccine. Judicial Watch has been second to none in filing Freedom of Information Act requests and getting access to documents through those requests and lawsuits, because Fauci and his people don't want to give us the information, so we have to sue their agencies in federal court. So pretty much everything you know about the Wuhan Institute and Fauci and what he's been up to is thanks to Judicial Watch. Let's be clear, it's thanks to Judicial Watch. Now, did we uncover everything? No. But pretty much everything that you think you know about what was Fauci, how much money did they give the Wuhan Institute? We got that out. How much money was Fauci getting paid? What was his job title and description? Oh, we got that out. Well, what were the concerns about the vaccine? Were there any issues with the way it was being tested? And what did the studies show about things that people should be concerned about related to the vaccine? Oh, we got that out through Freedom of Information Act requests. And I encourage you to go to our website and look at them, the various documents we've gotten, because there are thousands of documents that we're talking about here. And I'll go through some of the background on what we've been able to get out a little bit later. But most recently, we were able to get out information as a result, as I said, of Freedom of Information Act lawsuit. So this was not voluntarily disgorged to Judicial Watch. We had to fight for it. It took over 2 years to get this information. And it turns out, according to new documents given to us by the National Institutes of Health, the infamous Fauci agency grant that benefited in part the Wuhan Institute was the subject of an FBI inquiry. Now, you may recall that Fauci and his ilk were saying, oh, there's nothing to worry about. There was no gain of function research. Why would anyone be worried about this grant? Well, the FBI was worried about the grant because the documents show back in March of 2020, they had an inquiry about the grant. Other documents show that the Fauci's agency was very much concerned about gain of function research at the Wuhan Institute and for the grant, the larger grant generally, as far back as 2016. Now, what is gain of function research? Essentially, it's taking a virus or a biologic some way of some sort and making it more virulent, making it more likely by genetic or other manipulation to be dangerous to human beings or infectious for whatever other purpose that the researcher thinks it's useful. Now, the thinking is, if we know what the virus can do, if it's made more infectious, we'll be able to protect ourselves against it. Well, A, that's dubious logic, but B, it's also quite dangerous, because if the virus is made more infectious and gets out, do I need to tell you how dangerous that is? And of course, that's the concern about what was going on at the Wuhan Institute. They were engaged in gain of function research related to the bat coronavirus. That's not in dispute because Judicial Watch got the document showing it was gain of function research that was going on. It's been confirmed by Judicial Watch FOIA requests. And the thinking is, it was this COVID-19 a man-made virus? Now, has it been conclusively proven it's a man-made virus? No, there's a big debate in the health community about it. But it used to be that if I said this a year ago, I would have been knocked off of YouTube because they were interested in covering this up to help Fauci, to help China, and to make life miserable for Trump back in 2020. The censorship was so evil and corrupt in that regard. Now I guess I'm allowed to talk about it. So not only was this a FBI inquiry, but it shows back, as I said, back in 2016, they knew that there was a gain of function issue with this EcoHealth Alliance, which was the nonprofit organization that was getting this funding and then dispersing it to the Wuhan Institute and other places in China and abroad. The documents also show that the EcoHealth people didn't want documents turned over under FOIA, and they were saying, because of January 6th. How do you like that? Using the controversy of January 6th as a reason to withhold information about what government money was being used for in terms of creating potentially dangerous viruses? Geez Louise. Now, you probably haven't heard about this yet, have you? Right? You're hearing about it for the first time, unless you saw our press release about it. Ask yourself why you haven't heard about it. Don't you think it's big news that the FBI was investigating Fauci? Well, not him directly, but his grant. What's the status of that investigation? We don't know. Don't you think the media should be telling you about that if it were honest? Obviously, it's not. This is why Judicial Watch's work is so essential, because we give you information the media purposely withholds from you about what your government's up to. We are the citizen watchdog par none. This is the big email. Maybe we can put it on the screen. So you can see it's heavily redacted. Most of it is just blacked out. The email was dated May of 2020, and its subject line is Grant Questions, FBI Inquiry. And Ashley Sanders, a senior investigative officer with the NIH Division of Program Integrity, within the NIH's Office of Management Assessment, emails an agent in the FBI's Newark field office to inform him that in preparation for our call on Tuesday, we've provided responses, and I've taken out a few names there to make it more sensible to you. I've provided responses to your initial questions below. Guess what? They didn't give us the responses to the questions. So you have the Biden administration, and particularly Fauci's agency, the NIH. His agency is a sub-agency of the NIH, National Institute for Allergy and Infectious Diseases, I think is the official title. Also copied on the email is someone in the Office of Director for NIH, Francis Collins at the time. So they're hiding from us the nature of the FBI inquiry, citing deliberative process privilege. Now, deliberative process privilege, that's purely discretionary. It's not like secret information. They don't want to share this information because it might harm the deliberative process of the government. And we've known before in this litigation, because this litigation has been going on for some time, that the government has because the government has told us that one of the reasons it takes forever and a day for us to get these documents is, as I said, we began asking questions about what was going on with the Wuhan Institute and funding for it back in April of 2020. What's today? Where are we? In the middle of July? So we got these documents a few weeks ago. 2 years and a federal lawsuit. And one of the reasons they're telling us they can only give us the documents in dribs and drabs and still heavily redacted is because Fauci and his people have to personally review them. So yes, Fauci's responsible in part, I don't know for delaying this particular batch, but for delaying key documents about what his agency was up to in China. Documents that Judicial Watch has uncovered that have blown out of the water all of his dishonesty about what was going on. And we know from the grant numbers referenced in the FBI inquiry email that they were specifically looking at the mother of all grants in terms of COVID-19, understanding the risk of bat coronavirus emergence. That was the grant they were all nervous about as funding gain-of-function research in China and perhaps causing COVID-19. They were worried about it. They pretended they weren't, and we've talked about it before, and you've probably seen it elsewhere. I know Rand Paul's been talking about it, but they were pretending they weren't and telling the public that, oh, no, don't worry about it. They were very worried about it behind the scenes, the documents show. The records reveal several indications, as I said, of gain-of-function research, as well as failures to comply with reporting regulations, including a May 9th, 2016 email marked high importance, in which an NIH official notes Peter Daszak, and he's the top official at EcoHealth, his failure to file a progress report on this bat coronavirus research. This is the second communication from NIAID, Fauci's agency, requesting that you file a progress report for the above referenced grant that was due no later than April 15th. So this is almost a month later. Please submit the delinquent report by May 12th. Please be advised that continued late submission of your non-competing grant progress report and any subsequently requested documentation will result in a reduction of time and/or funds for this grant. Non-compete. So that means this was a special grant. Sometimes grants are competitive in the sense that you've got more than one applicant seeking the one pot of money. Well, this was a special grant only for EcoHealth, according to this email. And they weren't even complying with the basic rules because back in 2014, gain of function research was, because of the issues I've raised, because it's so darn dangerous, it was severely limited. Severely limited. And here it became obvious that they had concerns about it. So this email gets sent saying, you're not giving us a progress report on this grant. And they also send us someone else's email who's attached to this email. So you get all these email chains. And another NIAID official says, hey, look, they have proposed work for the next years of the award that may be subject to the gain of function funding pause. So they're not getting reports on what they're up to. And their guy warns their colleague, Fauci's guy warns another Fauci person, hey, they're going to be getting into gain of function, it looks like. And then they get an admission from EcoHealth that says, we received a warning that one of the publications listed from the past year is non-compliant. Well, what was it non-compliant with? Gain of function? That's what it suggests based on the email traffic. And then later in the month, we have additional confirmation. And this is 4 years before we find out about COVID. In a letter dated May 28, 2016, from NIH official Jenny Greer to NIH program manager Eric Stemme, who had been involved, who already knew about this gain of function scheme that was coming up. The officials advised this EcoHealth chief of staff person who said, yeah, we had a problem, that the NIH grant for the Wuhan Bat Project may include gain of function research that is subject to the U.S. government funding pause issued on October 17, 2014. They added that this pause was based on the following line in the grant application. So they told them they were doing gain of function research. And the line was aim 3, testing predictions of COVID interspecies transmission. So this is Fauci's agency looking at this grant application and recognizing that gain of function research was taking place or was being proposed. And this is also confirmation that Fauci's agency was told that it likely had taken place already, despite the funding prohibition. June 2016, the DASIC Award, the EcoHealth Award, may have GOF, gain of function. And I've been in touch with the grants management specialist for a while now. So this is percolating years before we find out about COVID, and years before we find separate email traffic, and we hear about these phone calls and such, where they're all nervous about this grant and want the details on it because they recognize that if it was involving gain of function research, it was involving the Wuhan Institute, then it could have involved the creation of COVID-19, if indeed COVID-19 turned out to be actually manufactured as opposed to naturally occurring. And it wasn't just the Wuhan Institute that was getting money from this grant. This is the dirty little secret. Who knows who else was getting gain of function research money? Well, actually we do, because we've got the sub-awardees as a result of this FOIA lawsuit. The Wuhan Institute of Virology in China, the Institute of Pathogen Biology in China, a Duke NUS in Singapore, a clinic in Burma, an entity in Cambodia, Indonesia, Malaysia, Thailand, Vietnam, Laos. And East China Normal University, China is listed as a consultant. So all of this involved, according to the documents, gain of function type research potentially. And if we've disclosed just in the last month or two, that there was a lot of gain of function research illicitly going on here in the United States as well, under what I call the public health deep state, whether it be the Department of Agriculture, the FDA, or NIH. And so, incredibly, despite all the controversy about gain-of-function research, the documents show that in August of 2021, which is what, a year and a half, well over a year and a half after all this controversy emerges, Daszak goes back and asks for gain-of-function money again. It's not clear what money he got, but certainly there was money that we know was budgeted for China that had already gone out, because documents show at least, for instance, $66,000 of the award was budgeted for China specifically between the year 2014 and 2019. So why would they go back for more gain-of-function money in 2021? Because they knew Fauci liked it. Fauci keeps on defending it. And all of this is at odds with Fauci's testimony, where he was kept on saying that there was no gain-of-function research. Of course there was. First of all, we know he saw the grant application because he's copied on the email. I think he responded to it, detailing gain-of-function research. And we know his people in the agency knew that gain-of-function research was going on. You know, and another outrageous document is that the NIH is just trying to get information on the gain-of-function research from EcoHealth Alliance, which is responsible for it. And Daszak and people at EcoHealth write back saying, oh, well, it's going to be hard for us to get this from the Wuhan Institute because you're not giving us any money anymore. So they're holding hostage to public health to getting more federal money for their dubious research. And one of the reasons we weren't able to get some of these documents is because, at least in a timely way, the document suggests, is because the EcoHealth Alliance was throwing up all these objections. Daszak writes, because he wanted the NIH wanted biosafety reports from the Wuhan Institute, given the intense geopolitical pressure around the accusations that the Wuhan Institute of Virology intentionally or accidentally released SARS-CoV-2, something which the WHO mission deemed extremely unlikely. And what's interesting, of course, is Daszak doesn't say that, oh, by the way, when you hear expert opinions that it was unlikely that it was engineered, I was involved in coming up with some of those expert opinions, even though he had the conflict. He said obtaining such information from the Wuhan Institute that he funded using our tax dollars is not a plausible option at present. This is in January 2021. And in responding and processing, because NIH wanted some help from EcoHealth in responding to our FOIA request. And they said that as demonstrated by the recent attack on the U.S. Capitol fueled by disinformation and conspiracy theories, the need to protect the privacy of EcoHealth Alliance employees and affiliates is more important than ever. So here you have the slow rolling of documents using January 6th as an excuse. Outrageous. And they still, in April, hadn't provided all the information they needed according to the documents. So this is pretty incredible stuff. And I just gave you, frankly, a taste of it because we have 1,651 pages. I can't go through it all here. Our press release as it is 8 pages. Initially, it was double that. So there's a lot more in the documents. And I encourage you, dear listener, dear viewer, to go on our website and look at the documents and see what else is there. And share the wealth and share the information. Do crowdsourcing analysis of the documents Judicial Watch has uncovered. Now, as I said, Judicial Watch has been second to none in trying to get information out. We showed that the funding money given to the Wuhan Institute generally, at least made available for the Wuhan Institute, was $867,000. Judicial Watch got that information out initially, a lot more than had been previously known But Judicial Watch figured out what was going on thanks to FOIA. They had 9 China-related grants to EcoHealth Alliance. Judicial Watch uncovered that. And in this batch of records that talked about the grants, they included an email from a top official at the Wuhan Institute asking for help finding disinfectants for decontamination of the suits they use to deal with the biologics and indoor surfaces. They didn't know how to keep the place clean. What a nightmare. HHS records included an urgent for Dr. Fauci email chain citing ties between the Wuhan lab and the taxpayer-funded EcoHealth Alliance. The government emails also reported that the foundation of U.S. billionaire Bill Gates worked closely with the Chinese government to pave the way for Chinese-produced medications to be sold outside China and, quote, help raise China's voice of governance by placing representatives from China on important international councils as a high-level commitment from China. So here we have interesting documents not only about the guilty knowledge, in my view, about the EcoHealth Alliance and Wuhan Institute funding by Fauci, but interesting information showing that the Gates Foundation was essentially, it looks like according to these documents, acting hand in glove with the Chinese government, the Chinese Communist government, to advance the interests of the Chinese Communist government. Incredible stuff. Again, we got the underlying gain-of-function research application, or grant application, that confirmed that they were funding gain-of-function research, despite what Fauci's telling you. And we've got all this stuff on the vaccines that that will shock you as well, that raise questions about how its safety was verified and validated by the companies promoting them. I encourage you to go to our website and read about that. So as I point out, no one's doing more than Judicial Watch to get information about this. Now, I don't know what the FBI is doing to get back to the beginning. Again, the headline is the FBI had been, at least at one point, investigating the infamous Wuhan grant by Fauci's agency. Is the FBI still doing it? Well, they ought to be. Because if they weren't supposed to be using this money for gain-of-function research. It turns out they were. And in my view, that's evidence of fraud. Who knew what and when about this fraud? And when you look at the testimony of Fauci, to me, at least, he's being dishonest. That ought to be under investigation. As I say, this incredible disclosure of an FBI inquiry shows that Fauci and others involved in this scandal were being dishonest in dismissing the seriousness of questions about their cover-up of their funding of dangerous gain-of-function research in China. Any FBI inquiry would be appropriate, as these documents extracted by Judicial Watch after years of stonewalling also show that Fauci's agency knew and should have known, going back to 2016, that it funded dangerous and prohibited gain-of-function research in China. Now, I don't trust the FBI, but they're the only agency that's supposed to be investigating crimes at the federal level at this stage of the game. So there's got to be some accountability here. Now, hopefully, as a result of these Judicial Watch disclosures, there'll eventually be more pressure to engage in this accountability. So I encourage you, when you're calling your members of Congress and communicating with them, say, are you following what Judicial Watch is doing on Fauci and company? And if they're not, they should be. Because if they had their druthers, they'd do this funding again. They'd do this research again. Now, because I mentioned COVID-19, and despite the fact I quoted documents, government documents, what happens is if you're watching this on YouTube or on Facebook or a lot of the other big social media platforms, it is likely there is a label that is vandalizing this video that suggests that to get the real truth on COVID, click here. So suggesting that what we're saying is not right and encouraging suppression and kind of scaring people from sharing it. So if you think this information is valuable, I encourage you to share, comment, and like in any way appropriate, depending on the platform, to get the word out to overcome the suppression of information like this from big tech media, from big tech social media that have become agents of the government in terms of suppressing information about government corruption by groups like Judicial Watch. And again, I encourage you to support Judicial Watch. If you think this information is important, I think it's important. COVID's killed millions of people. The left has used it to try to destroy Western civilization, to be blunt. These vaccines are a whole other ball of wax. And so we're going to ask questions about COVID-19, its origins, how things were handled in terms of managing the epidemic and pandemic, and how these vaccines were approved and how are they being pushed. We have a right to as much information as we can get about COVID-19 and the safety and efficacy and other background on these vaccines. And we're going to keep on pushing. And if you think that's important, I encourage you to go to our website at judicialwatch.org, find out more about this information, and support our work. And so, and I don't mean that by just sharing it. I mean that give us a donation. We can't do it without your support. Judicial Watch has filed a lawsuit for more accountability on January 6th. We asked for these records under the law, and they said to us, the Capitol Police, and we have the letter, they're not public records. So this is what Judicial Watch is doing. We have FOIAs on the outside agencies, and we have this lawsuit against Congress. What are Nancy Pelosi and Chuck Schumer hiding? In my experience, when they don't want to turn over information that easily can be turned over, it means they have something to hide. We've had to sue the Capitol Hill Police Department for basic information. We want the records. We're in federal court now to try to get the records. What's the state secret that we can't see this material? The public has a right to know about how Congress handled the security. I don't like the way the Justice Department is handling this. I don't trust the Justice Department. I don't trust the FBI. We're not going to stop investigating what went on because we don't trust Nancy Pelosi to investigate it. Frankly, we don't trust any politician to investigate it. Who needs a commission when you got Judicial Watch? Next up, in terms of good court news, is a big victory in California. I've been telling you about Judicial Watch's taxpayer lawsuits against the leftists in California who have decided that laws against discrimination, specifically in the California Constitution, don't matter anymore. And they were going to require, in a set of 2 laws, the first law that was passed, gender quotas on boards of directors for public companies. That if you're a publicly traded company, after a certain amount of time, depending on the size of your board, you had to have a certain number of women on the board. So that meant that there would be slots on the board that no man could apply for. Outright discrimination, obviously barred by law in the Constitution. But the radical left in California legislature and the governor didn't care, even as they were signing it into law. Both the legislature and the governor, as they're considering this, they understood it was constitutionally infirm. But the extremist left, they don't care about the rule of law, and they're just trying to see what works and what they can get away with. And what Judicial Watch did was we sued that law, on behalf of taxpayer clients. So taxpayers in California have the right to challenge laws like that when tax dollars are being used to pay for illicit activity, which is this discriminatory quota program. And so what happened is the legislature then doubled down and passed a second law. And the second law required discrimination and quotas on the basis of race, ethnicity, and LGBT status. That was similarly constitutionally infirm, but they didn't care and they passed it anyway. So what did Judicial Watch do? Judicial Watch filed a second lawsuit on behalf of taxpayers. And kudos to our clients who stepped forward here, our citizen clients in California. And in the first case, the gender case, we went to trial. And the trial, I've been talking about it if you've been following us, the trial just ended a few weeks ago, or maybe about a month ago. We don't have a decision yet. It lasted several weeks, but the court hasn't made a decision yet. It was before the judge. It wasn't before a jury. And so we expect the judge to make a decision soon. But in the second case, the case against the race quotas, we won. We won. We went to a hearing, as I disclosed to you before, where the court was considering motions for summary judgment by us and the defendants. And motions for summary judgment are essentially, we should win without a trial. And of course, the defense says they should win without a trial. And the court ruled as unconstitutional this quota scheme that the legislature put out there, requiring that boards of directors fulfill some type of quota scheme based on race, ethnicity, and LGBT status. It was an historic ruling because it would be Katie bar the door if that court allowed it to go forward. Because you can bet the left would have been right out there pushing for quotas all over the country. And here in this case, it was a state court judge who made the ruling based on the plain language of the Constitution in California and found the court or found the state's arguments wanting. So weak that he didn't need a trial to figure out what was up and what was down. And so he issued the ruling. It was last Friday. I think it was shortly after I did our weekly update last week. And right? I don't think we talked about it last week, right? And so it was a one-page ruling saying, you know, I'm granting summary judgment. And boom, the news was all over the country. And then on Monday, we got a hold of the decision, which described his thinking. But I tell you, this is big news because this is a historic victory, as I said, that is going to set a precedent and have national implications. What did I say? You know, it's funny. I do these press releases, and we think very carefully about what I'll say with respect to these big cases, and then I don't repeat myself on important videos like this. So I think it's worth highlighting what I said. This historic California court decision declared unconstitutional one of the most blatant and significant attacks in the modern era on constitutional prohibitions against discrimination. In its ruling, the court upheld the core American value of equal protection under the law. Judicial Watch's taxpayer clients are heroes for standing up for civil rights against the left's pernicious efforts to undo anti-discrimination protections. You know, and as we noted in one of our pleadings before the court, which is our motion for summary judgment specifically, and this is simple, laws that explicitly distinguish between individuals on racial or ethnic, sexual preference, and transgender status grounds fall within the core prohibition of the Equal Protection Clause. Indeed, a Senate floor analysis, this is in the California Senate, produced during deliberation on the legislation, concluded that the bill draws distinctions based on race and ethnicity, and therefore it is suspect, and that the existence of general societal discrimination will not ordinarily satisfy courts. And then in the Assembly of California, they found that the bill would result in ongoing costs in the hundreds of thousands of dollars to gather demographic information and compile a report on this data on its internet website. So that is what, by the way, that's what you can't spend. That's where we come in and say, well, you can't spend money doing illegal activity like that to engage in discrimination as part of a mandate for discrimination. And what was the state's defense? Well, we're not enforcing the law. I mean, they're so proud of the law, they won't enforce it because they know it's suspect. So here is the decision that we were able to, the judge issued. It's a 24-page decision, and the title of the case is Crest et al. Versus Bedelia. The legislature, and the court, I didn't agree necessarily with everything the court said, and you'll see why here. There's nothing outlandish or incredible about the idea that people generally tend to socialize with and select other people like themselves. The natural result of this tendency is the exclusion of people who look and act differently. And the natural result of that exclusion is the loss of the acumen that those different people would bring to a conversation, business, or any other group. The underlying premise here is that demographic diversity is a reasonable proxy for differing perspectives and life experiences. That premise is not seriously challenged by anyone involved in this case. I don't know if that's necessarily true, but it's what the judge said. If demographically homogeneous boards are a problem, then heterogeneous boards are the immediate and obvious solution. But that doesn't mean the legislature can skip directly to mandating heterogeneous boards. The difficulty is that the legislature is thinking in group terms, but the California Constitution protects the rights of individuals. And that's something the court emphasized directly. I'm not emphasizing this. It's in the decision. The rights of individuals to equal treatment. Before the legislature may require that members of one group be given certain board seats, it must first try to create neutral conditions under which qualified individuals from any group can succeed. That attempt was not made in this case. And that to me is an important insight. It's not like an important insight. It is an important insight, which is that the left wants to treat you as a member of a group. And of course, our Constitution doesn't generally protect group rights. It protects you from being targeted because you are a member of a group. But the core truth of the Constitution and the core genius of the Constitution is designed to protect our individual liberties. It sets up a structure of government to protect our individual liberties, not groups of people. And if you want to destroy your liberties, let the government tell you, you benefit or are punished because of a membership in a group. That's at odds with the American tradition and American rule of law. And that's what they were trying to do in California. Really radical stuff. So it's a lengthy opinion. I obviously can't read it all, but I'm going to read some of it because I know you're not going to read it all either. And this is a discussion of the Equal Protection Clause of the Constitution of California. Article 1, Section 7 of the California Constitution says, a person may not be deprived of life, liberty, or property without due process of law or denied equal protection of the law. A citizen or class of citizens may not be granted privileges or immunities not granted on the same terms to all citizens. Privileges or immunities granted by the legislature may be altered or revoked. So the point is, you all have to be treated equally in California. That's even stronger than the language of the Constitution of the United States. And there was a major case that the shorthand way of describing it is Connerly. And it's the governing precedent in California. A legislative classification satisfies equal protection of the law so long as persons similarly situated with respect to legitimate purpose of the law receive like treatment. So again, no race-based favoritism, no race-based set-asides. Or in this case, race, ethnicity, and LGBT status. So they've even broadened it. And I'm not even getting into the question of the self-identifying nature of those categories that the left is now embracing, which kind of blows everything else out of the water in ways that, we could spend 3 hours talking through the ramifications of that. Legislative classifications generally are entitled to judicial deference. However, judicial deference does not extend to laws that employ suspect classifications, such as race. So think about this. It's like, well, you can say, well, that person lives in that jurisdiction and that person lives in that jurisdiction, and we're going to treat them equally and, or maybe someone will benefit more because they live in a different jurisdiction. But the idea that you say that person is this race and that person is that race, and then treat them differently, no. The courts look askance at that for good reason, as you might imagine. Because suspect classifications are pernicious, and are so rarely relevant to a legitimate governmental purpose, they are subjected to strict judicial scrutiny. I.e., they may be upheld only if they are shown to be necessary for furtherance of a compelling state interest, and they address the interest through the least restrictive means available. So, again, I'm not a lawyer, so bear with me here. In order for this type of scheme to work, the government has to prove, and it's up to them to prove, in my view, and I think legally it is too, but certainly it makes sense. It would be, they'd have to prove this, that, look, there is a compelling state interest here, and it's the least restrictive means available. So it can't be extreme or aggressive. And by the way, it's got to be really compelling what the state interest is. And what the government was saying is that, well, yeah, these are suspect classifications. The compelling state interests are the following: remedying racial discrimination. And the other compelling interest is it's good for business. And if it's good for business, we'll get more taxes from it. And the court said, well, neither of those are good enough. And this is why. Yeah, so the court found that just citing general societal discrimination ain't good enough. You have to have specific instances of discrimination that would allow, and only then that might allow the state to say, well, yeah, this person was discriminated on the basis of race. John Smith. And therefore he has to be hired. Or, someone had this practice of excluding blacks from jobs because they were black. So therefore there's a remedy that gives preference to certain job applicants who are black. That's a very narrow remedy. And obviously, there's no doubt, by the way, that these categories of suspect classifications, there's no doubt this law triggers the sort of scrutiny that we're talking about. It requires corporations to have a specific number of directors who are members of certain listed races or else have certain listed sexual orientations or gender identities. People of other races, orientations, and identities are necessarily excluded from these board seats. I really can't believe we're even having to talk about this in this day and age. I mean, first of all, we got the federal Constitution, the 14th Amendment that requires equal protection under the law. And then we've had subsequent civil rights statutes that have been passed in the decades after that, mostly in the 60s and such. And then the state variations of it and changes to state constitutions. And here we are, 60 years later, at least from the 60s, and they're trying to undo all of that, the left is. And with regard to the economic argument, it's good for business. Well, first of all, we beg to differ. Discrimination's never good for business. Because that's what this is about. This isn't a question of, oh, let's have diversity or let's have people from various backgrounds on the boards and think that's not the issue. The issue is, do you tell people you can't apply because of your race or because you have the wrong sexual identity? Of course not. And the court highlighted, if, under the idea that it's good for business, that means you could get the government to do anything in terms of mandating discrimination as long as they massage the numbers properly. So that was a big loss. So this is how the judge concludes. A member of the public, whom all three branches of government serve, might wonder at this result, given some of the concessions made in the record. And he's talking about the value of diversity. If the legislature has identified a social problem, how can the court stand in the way of the obvious and direct approach to solving it? There are two complementary answers to the question. The first comes from the differing functions accorded to the different branches. It is the function of the judicial branch to resolve disputes. Courts serve that function in part by maintaining the continuity of rules even against the will of a majority. Residents of all stripes can feel more at home and more at peace with one another if they know the rules are stable, even when they don't like those rules. The second is that fundamental values, whether personal or social, must be guarded. equal treatment and opportunity of all and for all individuals, regardless of how they look or identify, is one of this state's basic commitments. Sometimes, and in some places, the citizens of this state will not live up to that ideal, meaning they'll engage in discrimination. But the thing that caused the problem, discrimination, is not always the right tool to fix the problem. Only in very particular cases should discrimination be remedied by more discrimination. And that should only happen after obvious alternative measures have been tried. Sometimes a direct approach should be the last resort, not the first. Now, this is the judge who wrote that. That's Judge Terry Green. He's a judge at the Superior Court in California. And you know, he's a judge in California. I don't necessarily agree with his analysis there in terms of how charitable he was to the California state legislature's pernicious racism or racial quota scheme. But his point is that if you're concerned about race in our nation's public life, if you want people to be treated according to the content of their character, you got to follow the rules, and you can't cheat. And you can't say this person gets a special benefit because of the color of their skin. And it's rare that I quote Chief Justice Roberts, or in this case, I may misquote him, but I think I'm getting the general gist of his quote right. He said, the way to end racial discrimination is to stop discrimination based on race. I mean, the solution to race discrimination is not more race discrimination. And to be clear, as we litigated in the gender case, and we were prepared to litigate, and I think our expert probably would have been able to refute any arguments in this regard, they didn't really have evidence that there was discrimination. The highlight of the court's decision, or one of the highlights of the court's decision was, you know, they were talking about racial discrimination generally. Well, they didn't, because there wasn't enough numbers on the boards that fit in with the demography generally of race in California. Well, A, they were using national numbers, but B, they weren't looking at the group from which corporate board members are selected. So it was like a gamesmanship even with numbers. They couldn't even prove discrimination, let alone the level of the specific direct discrimination that would have resulted in a narrowly tailored remedy that would have allowed potentially for certain acknowledgement of race in certain hirings. So this is a big decision. And as I said in our subsequent release on that, describing the court's findings here in our California case, and as I said in one of our other statements about this case, California must treat its citizens equally everywhere. Every state should do that under the law, and not give discriminatory preferential treatment to some based on race, ethnicity, or LGBT status. The court ruling marks a watershed for the core American value of equal protection under the law for all Americans, and it warns against the pernicious racialism of the radical left. And what's interesting about this is the media reaction to it, because they really don't know what to say or do, because there is no legal justification for what went on here. I mean, I'm excited about this ruling, but I don't know what, I can't imagine we would have lost or should have lost, but you never know with the courts. So, I mean, it was clearly illegal. It was clearly unlawful what was going on here. As I highlighted, the governor and the legislature, they knew it was likely to be found unconstitutional. So, A, the headlines were, court rules against California's diversity requirements. Well, that's a nice way of saying, quotas. But secondly, the general left's approach now is, oh, well, we can't have government mandates maybe, but maybe we can get private mandates requiring discrimination on the basis of race and these other qualifications or other categories. So now the left is pushing the idea that we'll have private pressure and private investors will get the big Wall Street firms to force corporations to hire people based on race. Well, that's not legal either. This is pernicious, and it's not going to stop with this victory, unfortunately, because as I highlighted, the left says, okay, well, we'll just do this privately. Well, you can't discriminate on the basis of race in hiring people. I mean, do I have to explain that? But they don't care. They don't care, and they're continuing. I mean, Judicial Watch objected to this reporting requirement for boards of directors in the NASDAQ stock exchange. A reporting requirement that would have pushed, obviously, for categorizing people based on race, and then implicitly hiring them based on race and other categorizations. Again, suspect categorizations. And, you know, the Biden, well, maybe it's, well, forget about that joke. I sometimes get confused about who's running which administration. So the Biden Securities Exchange Commission blessed that. And then we have the NFL out there saying that they're going to require NFL teams to have a specific coaching position that can only be filled by someone of a particular race, or I don't remember if it's gender too or not. I think it was just race. Again, outright discrimination. So they're planning to violate the law. And of course, this Biden administration supports this. CRT, and this is critical theory, by the way, the idea that only by having someone of a different skin color are you blessed, are you vindicated, or is your organization valid? Obviously, that's not true. The question is, are you discriminating on the basis of race? And if you're not, it's no one else's business. It's no one else's business. But the critical theorists, they believe it's always their business. And if you don't agree, they'll come after you. Thanks for watching. Don't forget to hit that subscribe button and like our video down below.